Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, and this is I Now Pronounce You Divorce, our weekly podcast where we discuss legal issues that we have come up with our clients that we find interesting and we want to share with you. So today I'm joined by Rebecca Malone and Dan Cuneo, and we're going to talk about something that we hear all the time, and that is adultery. My spouse is cheating on me. I've cheated on my spouse. What can I do to prove adultery? What can I do to protect myself against adultery? And it comes up quite frequently. And so in coming up, we've gained a lot of experience on what to look for, some advice to give to people. At first, I really want to talk about what to do when you're coming to talk to us, or you're coming to talk to your attorney about, hey, I think my spouse is cheating. So first, I wanted to open it up to Rebecca, who's licensed in Virginia and North Carolina, to really talk about, what do you look for in that initial consultation when somebody comes to you to talk about adultery?
Sure. So a lot of the time with these cases, it's, the client has a feeling and they might have a little bit more than a feeling, but they just know that something isn't right. The way their spouse is acting, they're gone for long periods of time. They have weird excuses. They, come home under suspicious circumstances, all of those sorts of things. But in Virginia, it's a pretty high burden of proof. So just having that inclination, even having that, they've disappeared for long periods of time, it seems like they're doing something nefarious, whatever, is not going to be enough to prove adultery. And so really at that initial meeting, we're trying to get at, what sort of more solid evidence do you have or could you have that we would be able to use in order to prove your case? And so a lot of clients come in and they think that getting, a private investigator is going to be the end all be all, and that's just going to prove their case. They can just hire an investigator, sit back, and their case will be done and wrapped up in a bow for them. And really, that's not going to be enough. So Virginia, the burden is so high to prove, the actual act of adultery, that just having this circumstantial evidence of your spouse goes to someone else's house, they park their car, they walk in the door, they stay there for a few hours, they don't come out, until the next morning, whatever it is, right? And we've got photos of that, we've got videos, we've got whatever. That's not going to be enough in a Virginia court to prove that there's anything adulterous going on. So we have case law that says, even a spouse that went and spent the night in a hotel with somebody was not found to be adultery. Someone who's, gone and just stayed in someone else's house. Again, these time and time again, it's not going to be enough to prove your adultery case. So really in that first meeting, we want to get a handle on what is the basis for your feeling? What are you seeing? What could we get our hands on, maybe in conjunction with something from an investigator, that could be enough to get us to prove that adultery case. And then also being really cautious about where they're getting their information as well, which I'm sure we'll get into more.
Yeah, private investigators can be wonderful. I know you talk about the case law on it. Some private investigators actually get pictures of the act, right? They kind of stand outside the first floor window and put a tape recorder up to the window. And for a private investigator, that's fine. And that's a very specific carve out that for a private investigator, that's fine. Mm-hmm. So Dan, in your jurisdictions, when you're having that initial consultation, an initial talk with a client who's saying, hey, I think my spouse is cheating on me, what do you look for? What do you talk about with them?
Sure, that's a great question. It all starts with, what is the end game? Meaning, what is the client's purpose for bringing that up? What is their goal? And then I always advise what the law is, just so they have an idea. And it depends, as you mentioned, jurisdictions where I'm licensed at, and there's multiple. And in one jurisdiction, in Missouri in particular, it's a factor the court has to consider. So there's many factors the court has to consider by statute when looking at property, debt, and awarding attorney's fees. And conduct of the parties during the marriage, during the litigation are factors, but they're just factors. So it doesn't mean that the judge is going to say, oh, well, because this person had an affair, I'm going to do X. So it all goes back to knowing the judge you're in front of too. And a lot of judges here may do what we call an unequitable distribution of the property and the debt, meaning if you can prove that one spouse cheated or did something inappropriate, then maybe instead of a 50-50 split, it could be a 60-40 or 70-30. And so just really advising a client in that situation, what are we looking at? Because if your spouse had an affair, we're in front of this judge, I can tell you this judge could care less. You're really going to upset the judge because you're wasting the court's time talking about an affair. Then there makes no sense to do it. But if the person, and I'm sure we'll go into it later, but just to bring it up, if the person had an affair with someone that may harm your child or has other issues that could have an impact on the welfare of your child or children, then that's definitely relevant. So then we want to pursue that and see what we can find out. And another state in North Carolina, it's a crime. It could be a civil or it could be criminal. North Carolina is one of few states to where you can be punished and have an actual criminal trial because of an affair. But it has to be proven, of course, right? But then on the civil side, the courts, it could be a denial of spousal support. So there could be huge implications. And if you think, so if you're in North Carolina and you think your spouse is having an affair, it's definitely well worth the conversation to discuss, why do you think that they're having this affair? What are you observing? And Rebecca hit it on the nail as far as, are you seeing them come home late? Are they leaving early? Are they having these crazy excuses? Have they lost a lot of weight? Are they, changing the way that they dress? Are they just acting a little bit out of the ordinary from what you're used to? And then it's, okay, well, do you have access to their social media? And if you do, great, log in, see what you can find. But if you do not, then could it be potentially violating their privacy? Because the misnomer is, you're married and there's this privacy goes out the window, right? There's zero expectation that you have privacy, but you could be violating that for the other spouse. So you want to make sure that if you do not have access, that you're not hacking into it or having someone else go into it. Hiring a PI could be good, a private investigator. Is it worth the time and the money to prove it? Which goes back to talking to the client and advising them on where your license or where the case is going to be at, if it's worth pursuing. Another jurisdiction or state that I'm licensed in Illinois, the courts don't care. So the fact that your spouse had an affair, it stinks. And I'm sorry for those who have that happen to them, but it's something you do not want to pursue because you could potentially be sanctioned for that. And it's not even a factor that the court's going to consider. So you don't want to upset the judge and risk being sanctioned by presenting evidence that is essentially irrelevant. And the hardest conversations that I've had as a practitioner in speaking with clients is, what is that impact on the finances? Because you could be in a situation where the person had the affair, but you could still be paying maintenance or not receiving maintenance. So it really, at the first start is, where did the affair happen, and what are the remedies potentially available to you?
Yeah, exactly. And understanding what you're wanting to get from proving that the affair happened, right? Divorce is always emotional, and having somebody cheat on you is probably one of the more emotional things that we see, right? And they want to go have their day in court. They want to go be able to have this cathartic effect of saying, look, this is what happened to me. But understanding, and from our perspective, being honest with our clients and saying, look, I get it, but this is what you have to gain from it. This is what it's going to cost you if we do this. Is there a benefit to doing this? Is there a benefit to this cathartic effect that you're looking for? So, Rebecca, when people come in, Dan kind of touched on, and you kind of touched on evidence. When people come in and they have evidence of adultery, let's say the social media account, what are you looking for? Because, and I kind of narrow this down, with the advent of technology, we all know, a lot of us know our partner's 4-digit code to their phone. And then from their phone, everything's logged in. And you can get on their Facebook, you can get on their Instagram, download everything, but you're doing it from their phone. What kind of evidence are you looking for? And is there evidence that we can't use, even if it does tend to prove everything?
Yeah, absolutely. So that's a pretty loaded question. So what we advise a lot of the time if you have some information about an affair, is you want to go ahead and file your case because that gives you the right to conduct discovery. And by going through discovery, you can get the evidence that you need, but you can get it through the appropriate channels. So if someone's having conversations on social media, if they're having, text message conversations, if they're whatever it is, you might be able to get an order to do a forensic analysis on their phone. You can ask them to download their entire social media history and produce all of that. And you're doing it all a legal way, right? Versus you rooting through their phone, coming across something and trying to bring it to your attorney. Well, depending on how you got it and basically what the other person's expectation of privacy was, you could be violating federal wiretapping laws, and the attorney might be sanctioned for using it in any sort of way as part of the case. So your attorney is going to say, I don't want that, wherever it came from, get rid of it, and I don't want to see it again. I don't want to hear about it. We can't use it. So really, you're hurting your case by sort of acting as your own investigator a lot of the time. What we need is enough information that we can file something in good faith, that we have some sort of a basis, right? And then we can do some more digging and find some more evidence. So I had a case where there was a confession, just a verbal confession. Wife admitted to husband, I've been cheating on you. It's been going on for a long time, whatever. So that's it. That's all we need, right? We can go into court in good faith and say, she's been having an affair. We think it's with this guy, at least on these occasions, so on and so forth. And then what that gave us the right to do was conduct depositions of her paramour. So we brought him in for depositions and had him testify about the dates they went on and where they spent the night and the hotel rooms they rented and, all of the dirty details. And now we've gotten everything through the appropriate channels that we need to present this case in court and have it, meet the burden, meet the requirements to actually prove adultery. Getting back to what Dan was saying, though, making sure it's worthwhile. In this case, the wife would have been entitled to spousal support. And so in Virginia, if you prove someone has committed adultery, it can be a complete bar to them receiving spousal support. So she had been stay-at-home mom. She was partially disabled. They had been married for like 15 plus years. All the factors would have been in line for her to receive a good amount of spousal support from him. And that's why we went after the adultery case so much. So just getting to the point where you can file something and then get your evidence through the proper channels. That's going to be the best advice in that situation.
You said something I want to point out. It can be a bar to receiving spousal support.
Mm-hmm.
And that is a hard conversation to have with people. The can, not that it is a bar. Dan, I want to ask you the same question. When somebody comes to you and they have evidence, what are you looking for good evidence? What are you saying, please don't touch that evidence, get that away from me? What is your kind of standard on that?
Right. Clients come in and they're like, I have the smoking gun. Here it is. Let's just go after this person. Well, it's the question you have to ask. I mean, you're doing your due diligence, and it's unethical, I think, if you don't, as a practitioner, ask, where did you get this? How did you receive this? And have those discussions, because if they hacked into their phone, then that's one issue, right? If they have their passcode or their 4-digit code, as Rebecca was saying, what is the expectation of having that code, right? Is it just in case something happens, or were both of you go on each other's phones and just look around and share information and it is what it is? Then that's one thing. So you have to really start digging in, because once you have possession and knowledge of that evidence, and then you use it to conduct discovery or to file pleadings and things like that, if it all points back to it was obtained through improper methods or channels or illegally, then you're risking, one, having your pleadings and probably the majority of your case stricken, two, sanctions, and then not only sanctions against the client, but sanctions against you and your firm. But then three, you're putting your license at risk. And no practitioner should want to compromise or jeopardize their license based upon an assumption, right? So you have to dig in and ask those questions. The client may be offended or may not like it, but we have to know, because if it is obtained through the proper channels and methods, then you can take that and start really building your case for trial, for discovery, but most importantly for settlement. If the other side knows what you have, then you should hopefully be able to facilitate settlement. And if not, then you have all that information at your disposal to use in discovery. Deposition is a great tool to use. Requests for admissions are another great tool to use if you have the information obtained through the right way. But I always want to make sure that the clients know, and if they have obtained it through illegal ways, and they may not know it's illegal, and that's okay, but we need to advise them, and they just need to destroy that, because they cannot be able to use that. So just put it aside. We're not using it. But if they are in possession of it and we can use it, then let's start digging in and seeing what we can do to move your case forward.
Exactly. And you kind of brought up something that they may not know it's illegal. As we continue our evolution down the digitally stored evidence and everything being stored in a remotely accessible cloud, there's going to be times where we come into contact, we being the empirical, we come into contact with evidence that maybe we should not have come into contact with. I'll give a prime example. I had a client who was traveling overseas, and her family shared an iCloud account. And when she got overseas, she put in a new SIM card, something. But anyway, the iPhone downloaded husband's text messages on the iCloud account. She had done nothing nefarious. And it downloaded the entire history of an affair, pictures, videos, everything that you would need to prove adultery in Virginia. And so we used that to file the complaint for divorce because, in my opinion, she had done nothing nefarious to get that. She had taken no step. It was just a happy accident. We ended up going to court on a preliminary motion to decide whether or not this evidence could be used. So, rather than get all the way down the road with it, it was actually my idea, because the other side was saying, hey, this can't be used. I said, well, let's preliminary motion decide whether or not this evidence can be used, because in Virginia, adultery is a crime, like North Carolina. So you kind of have the fruit of the poisonous tree idea. So we had to decide whether or not that evidence would be allowed. And I'm not sure if it was a right decision or wrong decision. The judge allowed us to use the evidence, but I think that was quite a few years ago. I think as we continue our evolution down digitally stored information, that decision might have changed. The decision might have been like, hey, this wasn't anything. The husband had an expectation of privacy. This was a failure upon the cloud. How do you handle, Dan, when you have to tell somebody can't use that evidence?
Those are tough because they think they have that smoking gun. And when you have to deliver that bad news, it really just takes the wind out of their sail. But it's how you deliver it. And you don't want to come across and say, well, we can't use this because you obtained this illegally and you shouldn't have done this. It's more of, unfortunately, even though you are in possession of this and you have that knowledge, we can't use it because this is how it was obtained. And there is some reasonable expectation of privacy. Whether or not you agree with it, unfortunately, that's the law. And if we were to proceed forward with this, here's what we risk happening to your case. And hopefully at that time, they'll be a little bit more calmer and they'll be understanding as far as what those risks are. Now, that doesn't mean that we can't still pursue an affair, but we'd have to obtain it through the proper methods and channels. And that's when those discussions of here's what we can do, here's kind of what it's going to cost, and depending upon your jurisdiction, this is what the court may or may not rule on. And is it relevant to your particular case? And if it is, then it warrants further discussions. But if it's not, then it's one of those other tough conversations that we shouldn't really proceed this. Now, at the end of the day, it's the client's decision. If he or she wants to pursue it and it's in good faith, then I will. But I just want to make sure that they know kind of risk versus reward. Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.